Hello friends, Namaskaram, how are you? Myself is Dr. Jinesh Soni, I am an advocate. In today's class, we will study about section 141 of the NI Act. Are you having any idea about the subject? If you are not having any idea, please be seated, have patience, maintain a proper notebook with pen or pencil. Today we will study about section 141 of NI Act. First of all, we have to understand the basic concept. Section 141 of NI Act, inter alia, prescribe offences committed by company as per the protocol of NI Act. So basically, we could say that if a check bounce case is committed by the company, in that scenario, the company could be prosecuted as per Section 141 of the NI Act. It is to be noted that the provisions are mandatory in nature. If there is non-compliance or there is any diversion from the roots of Section 141 of the NI Act, in that scenario, the prosecution would be discarded by the consent court. Section 141 of the NI Act inter alia incorporate the principle of vicarious liability. Means when the offense is committed by the company, not only the company but also every person who is responsible to conduct the business of the company, and apart from that, every person who is in charge of the company could be prosecuted as per law. As we know that company is a juristic person, so whenever the offense is committed and it is duly proved, only fine could be imposed on the company. So basically, the body or person through whom the company is acting could be prosecuted and could be punished and could be imprisoned accordingly in case the offense is proved as per law. So basically, we could say that the key provision of section 141 of NI Act is the offense if committed by the company, the person who is in charge and responsible to conduct the business of the company is liable to be prosecuted along with the company as per the protocol of section 138, section 141 of the NI Act. So basically, the company in isolation could not be prosecuted, and in absence of company, the concerned persons could not be prosecuted. So, if the company is prosecuted and the concerned persons are not prosecuted, the prosecution would fail easier. And the company is not prosecuted and the concerned persons are prosecuted, in that scenario, also the prosecution would fail. So, not only the company but also every person who at the time of offense is in charge and responsible to conduct the business of the company shall be deemed to be guilty as per section 138 of the NI Act. So in general sense, we could say that the director and MD would be responsible. And apart from that, if the powers are delegated and given to the specific person, he would be responsible. And in case of firm, the partners would be responsible. So basically, the consent complainant has to show that the offense has been committed with consent of or by having the connivance of the concerned persons who are responsible, being in charge and being responsible to conduct the affair of the company. So, if the offense is said to be committed by the company, in that scenario, the compliances of section 141 of the NI Act is must. If there is non-compliance and there is non-specification about the liability, in that scenario, we could have the benefit. So, basically, we have to observe our entire case and have to find out the best course so that we could rescue ourselves in the effective way. So, the important legal principles are the vicarious liability could not be imposed in the automatic way, and apart from that, the complaint must contain the specific averment and it must contain the specification that the accused is in charge and responsible to conduct the business of the company, and mere averment that the concerned person is director is not sufficient. Specific averments must be on record, and if it is found that the concerned director is a sleeping director, and apart from that it is found that his capacity is of non-executive, in that scenario, as the concerned directors are not concerned with the affair of company, they could not be prosecuted. So basically, whenever the company is prosecuted, we have to observe that whether concerned complainant has done the compliances with section 141 of the NI Act or not. If the compliances are not done, in that scenario, we could have the benefit. And apart from that, two important judgments are quite important. One is pronounced by Honorable Supreme Court. Citation is 2025 SCC online Supreme Court page 5 to 8, and other one is pronounced by Honorable Kerala High Court, which is dated 23rd of Jan 2026. In both the cases, it is specified that whenever there is allegation on the company that the offense of check bounce has been committed, not only company but every person who is responsible, in charge, and responsible to conduct the business of the company are liable to be prosecuted as per section 138 and 141 of the NI Act. If the averments are non-specific and there is no specific role, in that scenario, the person could not be prosecuted. So whenever we are going to contest our case from defense point of view, we have to see the compliances. If there is non-compliance, we could have the benefit accordingly. So I think that I have specified you the basis of section 141 of the NI Act. See you in the next video. Till then, Jai Hind, Jai Bharat.